Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi taala wabarakatuh. I'm Muhammad Hasri bin Paino, would like to present about case of law on industrial relation between Malaysia Airlines System Berhad and Ismail Nasaruddin bin Abdul Wahab. Fact of the case, the claimant commenced employment with the company as a trainee flight steward with effect from 6 March 1989. Subsequently, the claimant was appointed as a flight steward with effect from 12 May 1989, whereby he was placed on probation for 4 months and thereafter he was confirmed in his position as a flight steward. Later, on 14 August 1995, the claimant was promoted to the position of leading steward and was thereafter confirmed in this position on 14 November 1995. Sometime in 1996, the claimant was reassigned from a leading steward attached to a narrow-body aircraft to a leading steward attached to a wide-body aircraft. It was a lateral reassignment with no changes to the claimant's terms and conditions of appointment, save that the claimant was entitled to a higher allowance. The claimant was thereafter promoted to the position of chief steward on 8 December 1997. On 3 August 2003, the claimant was demoted from chief steward to leading steward for making statements pertaining the company to the media. However, the claimant was subsequently reinstated to the position of chief steward on 7 June 2007. On 8 November 2013, it was brought to the company's attention that the Sun newspaper was carrying an article on the National Union of Flight Attendants Malaysia, NUFAM, called for the resignation of the company's chief executive officer. The said published article referred to an interview of the claimant conducted with Sunbiz, whereby the said article also made reference to a press statement issued by NUFAM. The article also raised various other allegations against the company. At the material time, the claimant was the president of NUFAM and a member of its executive committee. Consequently, the company issued a letter of suspension dated 8 November 2013 to the claimant, suspending his service pending further investigation. And at the material time, the company was also investigating press release published in the Sun on 29 October 2013 and 4 November 2013. The issue of the case, there was no dispute as the fact that the claimant was dismissed. The court has to consider whether the charges preferred against the claimant have been proved, and if so, based on the evidence adduced, whether the charges are sufficient, serious to amount to just cause and excuse to warrant the claimant dismissal by the company. Whether the appellant act of alleged misconduct which involved his engagement in the trade union activities amount to misconduct warranting disciplinary action or dismissal. The High Court ground of judgment on the judicial review application state that viewed in totality and the fact that the statement was made in the applicant's capacity as the president of NUFAM for the interests of the members without involving any illegal act, the applicant's conduct cannot be labeled as a misconduct which warrants his dismissal. Considering all the facts, the federal court found that the union leader's press statement constituted participation in the legal activities of the trade union and was not unreasonable, malicious, or knowingly or recklessly false. Whether the respondent's dismissal was lawful, the appellant's act of illegal misconduct which involved his engagement in trade union activities does not amount to misconduct warranting disciplinary action or dismissal. As for that, the federal court agreed with the High Court that the union leader's conduct cannot be labeled as misconduct which warrants dismissal. In other words, an employer cannot dismiss an employee just because he or she despite the employee and there is no legitimate reason to support its dismissal. The Industrial Court ruled that Section 4 and 5 of Industrial Relations Act 1967 are inapplicable in this present case. It is not disputed that at the material time, the applicant was the president of Nufarm and one of its EXCO members. Nufarm is a registered trade union under the Trade Unions Act 1959. It is pertinent to analyze that relevant statutory provision in relation to employees involved in the trade union activities. Section 4 of 1 of the Industrial Relations Act 1967 states the following: no person shall interfere with, restrain, or call a workman or an employer in the exercise of his right to form and assist in the formation of and join a trade union and to participate in its lawful activities. It is also an offence to dismiss a workman as a trade union member seeking to improve working conditions as provided under Section 59 1D of the IRA 1967, which is as follows: subject to subsection 5(2), it shall be an offence to dismiss a workman or injure to injure him in his employment or alter or threaten to alter his position to his prejudice by reason of the circumstance that the workman, in D, being a member of a trade union which is seeking to improve working conditions, is dissatisfied with such working condition. On the judicial review application state that, view in totally it and the fact that the statement was made in the applicant capacity as the president of Nufarm for the interest of the members without involving any illegal act, the applicant's conduct cannot be labeled as a misconduct which warrants his dismissal. Based on the above, it is clear that the court viewed that the claimant had not committed any misconduct that warranted his dismissal from the company. Therefore, the total amount of back wages and compensation in lieu of reinstatement payable to the claimant is Ringgit Malaysia 211,444 and 56 cents. The court orders that the company pays the claimant the total sum of Ringgit Malaysia 211,444.56 less any statutory deduction through the claimant solicitors within 30 days from the date of this award. The main issues are: first is to what extent is an employee protected in respect of a charge of misconduct by an employer for act carried out in their capacity as a trade union officer or members. Second is whether the dismissal of the employee as the president of his organization trade union is an act of unfair labor practice. And third is whether it is necessary for a trade union officer to first exhaust the dispute phase in accordance to provision of the Industrial Relations Act before issuance of any press statement on the dispute. Court held that pursuant to Section 8 of the Employment Act 1955, a contract of service could not be used to contract out the right of employee to join, participate, or organize trade union activities. Moreover, the court held that a trade union officer was not obliged to exhaust the trade dispute process under Section 18, 19, and 26 of the Industrial Relations Act 1967 before issuing a press statement. The legislation scheme does not prohibit trade unions from issuing press statement as well. Therefore, the employee in the matter was within his right to issue a press statement on the dispute faced by himself and his peers. The court was also of the view that the press statement released by the employee was not malicious, wholly unreasonable, or extraneous. It was also found that the employee did not release the press statement out of personal interest but under its duty as his organization trade union president. Thus, his action did not amount to a misconduct. The decision signaled the court interpretation of the Industrial Relations Act 1967 and Trade Union Act 1959, in particular regarding trade union activities. The provisions relating to union representation and the prohibition of discrimination against workmen in their employment by reason of participating in trade union activities based on the federal court decision is squarely in favor and for participation of employee in trade union activities. This is a progress in workers' rights in Malaysia. The court decision could also be viewed as a recognition of the importance of trade union acting as a platform to provide speedy and just settlement of industrial dispute. Moreover, the federal court decision safeguard employees' right to participate in trade union activities. This development is beneficial to both the employer and employee, whereby an employer, in view of the stronger position of trade union, will have a better streamlined avenue to discuss employment and trade dispute with its employees collectively. On the other hand, an employee with grievance or trade dispute may approach the employer together with the trade union without any worry and concern of their status as employees. This promotes better communication and more effective resolution of conflict between an employer and employee.